The case I chose to talk about today is the Court of Appeal case of Nipissing Condominium Corporation. The Nipissing Condominium Corporation number 4 versus Simard. This is a Court of Appeal case that was issued just last month, at the end of last month. So really it's hot off the presses. But really that's not why I chose that case. I didn't choose the latest case and the Court of Appeal case for that. The significance of this case, quite simply, is that it has opened the door for the first time to condominium corporations to take compliance cases against unit owners through application rather than mediation and arbitration. And most of you probably understand the significance of that. So this is big. Okay, so before I speak about the case, let me give you a little bit of a background so you can understand the context of it. As you all know, the aim of the legislature is to, when it comes to disputes between unit owners and condominium corporations, is to move away from the courts and into mediation and arbitration. The courts basically are saying, don't bother us with these kinds of things. Go through the private mediation and arbitration procedures. And so the Act does it in two ways. First, the Act requires that condominium corporations and unit owners, if they have a dispute between them, basically they have to submit any disagreement that they may have between them with respect to the condominium declaration bylaws and rules to mediation and arbitration. Okay, so that's the basic requirement. Luckily, there are some exceptions. We all know that disputes between the unit owners and the corporation with respect to the Condominium Act don't have to be submitted to mediation and arbitration. And we also know that any disputes between the corporation and tenants also don't have to be submitted to mediation and arbitration. It would be good if we had more exemptions, but these are the two. But this Act probably might come into place, and I'll talk about it shortly. Now, to reinforce that, the Act also says that if the processes of mediation and arbitration are available, then the condominium corporation cannot apply to the court until it has tried and failed to obtain compliance through using those two processes. So that's how the Act works. The biggest problem, of course, with the Act is that it doesn't provide a definition of disagreement. So we don't really have the parameters to decide what sort of disagreement needs to be mediated and arbitrated. Of course, the courts came to rescue, and in the case of McKinstry versus YCC 472, the court came up with a rather broad and generous interpretation. And basically what they said is that it relates to disagreements with respect to the validity, interpretation, application, or non-application of the declaration bylaws and rules. So that's pretty well about as broad as you can get. And what it meant, essentially, is that if a unit owner disputed anything, even if it was the silliest thing, that essentially amounted to a disagreement according to McKinstry, and then you needed to go through mediation and arbitration. So for example, let's say the unit owner said, that rule is stupid, I don't have to follow it. Guess what? According to the definition set out in McKinstry, that is a disagreement with respect to the validity of that rule. So you had to go through mediation and arbitration, no matter what the merits of that unit owner's position was. So that's basically McKinstry, and McKinstry is law, and it has been followed since. And, or I should say, it has been law until this case came along. And before I talk about the case, let me just very briefly talk about the facts of the case. So Simard is the owner of a number of units in this condominium corporation, and he has leased his units to a number of tenants, so that in each unit there were several unrelated tenants living there. The condominium corporation had a provision in the declaration that said units are to be used as one family residence only. So the corporation proceeded by way of an application against both the unit owner and the tenants. Now, as against the unit owner, the corporation just requested compliance with sections 119 and 83 of the Condominium Act, requiring the unit owner to provide copies of the leases of their units to the condominium corporation. And as against the tenants, they sought first a declaration that the tenants are in breach of the condominium corporation's declaration, and an order that terminates their tenancies. So that's what the corporation asked for. The unit owner brought a motion seeking to set aside the application on the basis that the corporation didn't comply with the statutory mediation and arbitration provisions. And the motion judge, Justice Howden, dismissed that motion on essentially two grounds. First, he said, this case really is about a mix of issues that relate to the Act and that relate to the declaration. And in addition, it's a case that involves both unit owners and tenants. And therefore, it would be appropriate to have the whole case dealt with in one forum, the court, by way of an application, rather than to section off the case so that the case against the unit owner would proceed by way of mediation and arbitration, and the case against the tenants would proceed by way of application. So the court, I think, sensibly said that it would be a good idea to go ahead with the whole case by way of application. The other ground of Justice Howden for dismissing the motion was that he said that he is not fully bound to accept the generous interpretation set out in McKinstry, and that, in his opinion, if the dispute between the corporation and the unit owner was strictly with respect to the validity of that section of the section of the declaration bylaw or rule that was being enforced, and if there were no other disputes about the meaning of that section, or no other significant factual disputes between the parties, well, that's not a dispute, that's not a disagreement for the purposes of the Act that you need to go through to mediation and arbitration. So those were the two grounds. And having the motion dismissed, basically Justice Howden gave the green light to the corporation to proceed with the application. Except the owner appealed the decision of Justice Howden to the Court of Appeal. And the Court of Appeal dismissed the appeal on the ground that Justice Howden had both the jurisdiction and the discretion to decide not to section off the case and to let it all proceed in its entirety to application. Okay, so having dismissed the appeal on that basis, though, the Court of Appeal didn't deal with the other ground of appeal, which is Justice Howden's decision that if there is a dispute and the dispute is strictly with respect to the validity of that particular provision, it's not a disagreement for the purposes of the Act. Obviously, it would have been good if they would have done that, because we would have some clarity. Even if the court would have said, yes, we accept this decision or we reject that decision, at least we would know where we stand. And of course, the Court of Appeal also basically missed a wonderful opportunity to look again at the McKinstry case and give us some more parameters as to how we can handle these things. So that disappointment aside, the reason this case is significant is because now it gives the corporations two options they didn't have before. So if a corporation now has to go against both a unit owner and a tenant on a compliance case, now the corporation can think about going by way of an application with relatively little risk. And if you have a case now where it turns out the only dispute is with respect to the validity of that section that is sought to be enforced. Let's, for example, say the corporation has a rule, no snakes. Okay? And a unit owner has a nice boa constrictor. He goes and tells the corporation, look, this rule is unreasonable. My snake is very nice, is very friendly. Your rule is unreasonable, is invalid, not enforceable. So the owner is admitting they've got the snake. There are no factual disputes. And the only thing that is an issue is the enforceability of the rule, the validity of the rule. What it looks like, if you're faced with that kind of a case, you might now go by way of an application. At least this case gives us that go-ahead. So now, of course, it's not really settled law. This case is so fresh, Most people haven't yet seen it. So it will take some time to work with. But it's significant that it opened that door for us now. We can at least try it. And there are risks, of course, especially with the second option that I talked about. But at least with the first option, I think we have a very good, solid feeling about it, that it's relatively risk-free. I know others have different opinions about it, and I might hear about them. But in my view, that's really a significant case. And that is why this case is significant. Thank you very much.